Hi, Andy Nelson. Every so often I get asked by someone if they can start using a name or a logo or some other trademark of some brand from yesteryear or yesterdecade perhaps that they don't think is around any longer. Something that's long dead, but they would like to revive it. We see a lot of these kind of brands resurrected, so to speak. Some of those are probably from the same companies that have always put out those products or services. But sometimes companies just go away. And it could very well be that those marks are free to use. And here's why. So recall, trademarks themselves, to function, to be trademarks and that property, have to point, they have to function, right? They have to point to a single source of goods or services and kind of deliver that kind of promise of goodwill quality that comes along with it. If it doesn't do that, if a trademark doesn't do that or no longer does that, then it may be deemed what's called, in legal circles, abandoned. And that's the concept. Is a trademark abandoned? And if it's abandoned and no longer has that function it has to have in order to kind of be the property of a trademark owner, it may very well be free to use. Not something that should be taken lightly and should be done with some caution, care, and some research, probably with counsel, but it may very well be the case. Now, here's an interesting, very timely brand that may very well be free to use immediately or maybe in the near future. I don't know. And it's this one right here. And Jemima, a lot of you have probably seen the news that Quaker Oats is, I think what the terminology they're using is retiring the brand. I don't think they use the word abandonment, probably because legal counsel told them not to do so, but they're saying retiring. That may very well be, since I think the import of that is that they are no longer going to use the name, the imagery, period. That sounds a lot like abandonment of the mark. And if it's abandoned and no longer will function as a trademark for Quaker Oats being the source, at least the name, I'm not sure about the imagery, because the imagery may have copyright issues, and I'm not sure they're abandoning those or if they even own them, what the situation is. But the name itself, Aunt Jemima, may very well be abandoned through express abandonment. The company's saying they are not going to use it any longer. So that's one instance where it's not the usual instance. Usually you see companies just kind of die and fade away and they don't resume use. They cease use and then don't resume it. That's the rub. That's the question to be answered. Is it actually abandoned or is it just on hiatus for a bit? Again, something to research, not be casual about it. But with this, Aunt Jemima, you have express abandonment, it would appear anyway. I don't know, I'm not sure, so don't take this as gospel right here because I just don't know. But there are situations where you see companies do that, expressly abandon their rights, and I think we might see some more of that. Those things, and I say things because it could be a lot of distinctive things, maybe images, slogans, names, and other sorts of things that function as trademarks may very well be now or in the near future open for others to adopt if they so choose. But anyway, so, full circle, yes, if some folks want to adopt brand imagery, name slogans, etc., from yesteryear companies that are no longer around, it is possible to do so long as someone does the research correctly and determines that, in fact, those trademarks are, in fact, abandoned legally. Then they may be free to use. At any rate, if you have any questions about this video, please feel free to shoot me an email. Talk soon. Bye-bye.